Hello, my name is Ben Williams, the principal at Williams Intellectual Property. In this video, I'm going to answer the frequent question, what is the difference between a utility patent and a design patent? And which is better, and why? Well, first, a design patent has a very particular use, just as a utility patent has a very particular use, and it depends pretty much on the subject matter that the inventor considers his invention. So a design patent is directed toward an ornamental aesthetic of an object. So the ornamental concern, or the way something looks, that by definition really has no functional utility. It is merely an appearance. The utility patent, on the other hand, is directed to protect specific structure that enables a function, or the specific steps that comprise a method. A utility patent typically offers broader protection and protects across multiple embodiments when practicing the invention. So the particular form or arrangement of the necessary parts is still protected by the same disclosure, of course depending upon the language, and size, shape, and these arrangements of parts are irrelevant when practiced under a particular utility claim. A design patent, on the other hand, is fairly restricted to the illustrations that are filed with the application, and various minor modifications to the shape and appearance of the object can be deemed outside the scope of the design patent. So let me give you an example. The example I most like to give my clients is the example of a fish-shaped lamp. So the utility patent, let's say, in a simplified example, that might protect a lamp could have a claim that would have language along the lines of, we claim an illuminable member connectable in circuit with a switch, wherein depression of said switch affects illumination of the illuminable member. Now that claim, if it issued, would pretty much protect just about every type of electric lamp on the market today. The illuminable member includes LEDs, filamented bulbs, strip lights, really anything that could be illuminated when a switch connects said illuminable member in circuit with, I guess, a power supply. The only thing that would be outside of that patent, if it ever issued, would be a candle, say, because a candle, while it is an illuminable device, doesn't really have an illuminable member. And even if you could argue that the wick is an illuminable member, there really is no switch and probably no circuit. However, a gas lamp perhaps could have a circuit, and it could also have a switch. So a gas lamp might fall into a gray area, although arguably this circuit would be intended to include electrical circuitry, at least in the example I've given. It's probably more than we need to get into on this example. So the point being that the language of the utility patent, the illuminable member connectable in circuit with a switch, basically covers across multiple embodiments. Strip lights, filamented lights, round lamps, long lamps, just about every type of lamp that we can possibly imagine. A design patent, on the other hand, may be attained for this lamp if it was rendered in the shape of a fish. Now, granted, the owner of the fish-shaped lamp might indeed have to license the circuitry, the patent for the circuitry in the illuminable member, but he could potentially obtain a patent for the fish shape, because the shape of a fish in no wise affects the illuminability or the operation of the lamp, and therefore by definition has no utility. So that basically is the difference between a design patent and a utility patent. Of course, if I changed the shape of that fish and made it look more like a shark, and his fish looked more like a koi or a goldfish, then I wouldn't necessarily be infringing his design, because a design patent is very restricted to the way it appears and the way that it is presented in the illustrations at the time of filing. I hope this video has answered that question for you. Please feel free to give me a call, and thank you for watching this video.